Hello, everyone, and welcome. The American Red Cross IHL Dissemination Program is very excited to host today's event with Dr. Jens Iversen of Leiden University over the concept of Jus Post Bellum. Before I introduce our speaker, I would just like to first remind everyone to please post any questions or comments via the Q&A function and not the general chat if possible. If for any reason you cannot use the chat, say you're calling in, but still have a question, please try to raise your hand. And after we go through the questions in the Q&A, I will go through the list of people who have their hands raised in order in which they were raised. With that, I'd like to introduce our speaker, Dr. Jens Iversen, who is an expert in various aspects of public international law and the author of Jus Post Bellum, The Rediscovery, Foundations, and the Future of the Law of Transforming War into Peace. Dr. Iversen currently is an assistant professor at Leiden University, where he also earned his PhD. And prior to that, practiced law at the International Criminal Tribunal for the former Yugoslavia. So with that, I would like to introduce our speaker, Dr. Jens Iversen.
Thanks so much. So the subject of tonight's talk is the subject of my book, Jus Post Bellum. That's the name of the book. Then, as mentioned, right? Jus Post Bellum, The Rediscovery, Foundations, and the Future of the Law of Transforming War into Peace. But to be honest, I can't get into all of that in a brief presentation. So I had to choose a focus. And before I explain that choice, I, of course, want to thank my hosts and you, my audience, anyone I think who voluntarily joins a Zoom call in late 2021 is truly dedicated to the subject. I take it as an immense compliment that you've joined. The American Red Cross in general, and Eric Schmitz and Christian Jorgensen in particular, have been nothing but gracious and helpful in arranging this event. So thank you all. So in this presentation, I'm going to focus on why it's important that Jus Post Bellum is conceived of broadly and with an emphasis on function rather than time period. This argument, what I call in the book a hybrid functional approach to Jus Post Bellum, is one of the concepts at the core of my research. And to test it out, I'm going to do something I explicitly don't do in the book. It's not a book of case studies. But tonight, I'm going to see if thinking about Jus Post Bellum in this way, in a functional approach, might have helped us and might help us in the future in a particular situation that might be on many of our minds in Afghanistan. And if you stick around until the end, I'll tell you my own, perhaps novel theory of which US presidents are most to blame for the failure to achieve a just and sustainable peace there. I'm going to argue that if the way we think about law and principles, about war and peace, if these were better informed by the deep tradition in this area, we would do better with this transition, right? Now, in one chapter of my book, I review the works of Augustine, Aquinas, Baldus, Vittoria, Suarez, Gentili, Grotius, Wolf, Vattel, and Kant, amongst others. It's one of the larger chapters. And I do this with an eye towards pulling out how they treated this transition to peace. I obviously can't cover them all in this talk, but to study Afghanistan, I'd like to pull on a couple of them, particularly tonight, Augustine and Kant. So here's how I'll structure my brief talk. It's going to have 5 short parts, some shorter than others, answer 5 questions. I'm going to discuss why I think there should be a greater focus on Jus Post Bellum right now. Then discuss what Jus Post Bellum is anyway, and then I'll try to answer the question, what value is there in paying attention to the ancient traditions that used to inform our broad approach to war and peace? And the last 2 questions are, how can the specific goal of establishing a just and sustainable peace help inform legal decisions at this moment? And finally, what's next? So let's begin. So this first question, okay? Why focus on Jus Post Bellum right now? Again, I'm flattered you've chosen to listen to this talk, and asking why focus on Jus Post Bellum might be preaching to the choir in this case. But as a bit of a Jus Post Bellum evangelist, I don't want you to stop with this talk. I am hoping many of you will devote more of your energies in the future in this area. And the short answer is that the international community and states involved in armed conflict are generally bad at transitions to peace. And further, I think we're getting worse at it. Now that's broad generalization. For a longer answer, you'll perhaps let me indulge in recounting a bit of an insider's view of the development of the study of Jus Post Bellum. Others might tell a different story, but this is my story. So some of you remember a time after the Cold War, perhaps after the first Gulf War, where there was perhaps more optimism that we were, as an international community, really capable of managing successful transitions to peace. Maybe we were beginning to figure it out. We had, after all, with the Cold War, diffused international tension that had spawned proxy wars for decades, held out the threat of nuclear annihilation. And Kuwait had been restored to its rightful, if autocratic, rulers. Now, when I began to study Jus Post Bellum, I think the optimism of that era was closer in mind. I switched over from practicing international criminal law to the academic study of the transition from armed conflict to peace 10 years ago, in 2011. It was a very interesting time for the study of Jus Post Bellum. The conflict in Afghanistan had stretched 10 long years, but bin Laden had just been killed, so perhaps it was wrapping up. There was a new project at Leiden University focusing on the idea of Jus Post Bellum, which I was invited to join. And when I arrived, we renamed it the Jus Post Bellum Project, and it was very exciting. We published 3 volumes with Oxford University Press, put out special editions, held conferences, published articles, and I've recently published a volume. But there's little evidence, unfortunately, to demonstrate that we sufficiently penetrated into practice where it counts, that we're getting better as an international community at transitions from armed conflict to peace. The highest profile conflicts certainly don't seem like models we want to replicate. Iraq, Syria, Libya, Ukraine, Yemen, Nigeria, Somalia, Ethiopia today. Of course, the conflict that took place on the territories of Afghanistan and Pakistan. There are also, of course, imperfect but more successful transitions to peace, such as South Sudan, Colombia, but they're still fragile and flawed. I think there were 3 non-legal trends that were leading to perhaps misleading optimism after the Cold War, after the Gulf War: political, economic, and technological trends. In terms of political science, I think the collapse of Soviet Union led to the hope that that would lead to one accepted model for governance, just naturally, end of history. And this might lead to democratic peace. In terms of economics, the reduction in the number of desperately poor people worldwide might alleviate the demands for justice that lead to conflict and that can prevent conflict's end. And in terms of advances in military and communication technology, well, there was hope there too. There was hope that the military dominance displayed in the first Gulf War, the general ability of people to communicate with each other, would help us build consensus and maybe a durable peace after war. Well, things look different now. I suspect that the failures of these non-legal trends to go the way we hoped not only put us in a more difficult position now, but that they will actually make transitions to just and sustainable peace more difficult as we proceed. I think politically, cynicism towards and rejection of a democratic rules-based order is not only inviting collapse and democratic backsliding in many states, which may well lead to conflict, but more to the point for today's discussion, makes it hard to consolidate on a shared post-conflict vision of society, the idea that even that vision should be shared. In terms of economics and technology, well, imagine a future not too far away where an increasing number of armed groups can not only afford weapons that are hard to defend against, but also where the price of launching recruitment and misinformation campaigns has plummeted. So you can purchase, killer remotely operated weapons, biological weapons we haven't even focused on as much yet. Or they can buy millions of impressions online to argue that a conflict should continue and to force its continuation. I don't think current trends bode well. So I think we should pay more attention to legal and moral aspects of the successful exit from armed conflict, because given current trends, the horrors of war are very likely to worsen, deepen, and spread. If technology and economics operating on their own won't save us from a worsening future of wars that do not end in a just and sustainable way, and we can no longer assume that the allure of democracy will just naturally create success conditions for that goal, what do we do? When I discuss the litany of recent high-profile wars with my students or colleagues or friends, the response is increasingly despair or turning inward, sort of numbness. So perhaps at this troubled moment, it's worth returning to the reinforcement and remembering of legal traditions and moral principles undergirding this area of law after all. Okay, and this is amplified in my third question. What value is there in paying attention to the ancient traditions that used to inform our approach to war and peace? But before we get to that, I want to turn to my second question. All right, so what is Jus Post Bellum anyway? Okay, different people mean different things by it, and to answer what is the best definition for Jus Post Bellum, I'd like to put forward what I might call the naive temporal definition and explain why it's not as useful as a functional approach. So let's take Afghanistan. Well, strictly temporal approach, the way people often approach the tripartite division between Jus ad Bellum, Jus in Bello, and Jus Post Bellum. So part, the fault of using this term Jus Post Bellum has this emphasis on time, would say, well, we first ask the question, Jus ad Bellum, at the beginning, with the NATO invasion and the occupation of the country displacing Taliban rule. Is there a technical problem? Is there an audio problem? Are other people having audio problems? Okay, there was one, I'll continue that. So after that point, after this invasion, after the moment of Jus ad Bellum, we'd been in this 20-year period of Jus in Bello, where we wouldn't ask questions, really, of Jus ad Bellum or Jus Post Bellum. And we wouldn't ask Jus ad Bellum questions for two reasons. One is the naive temporal approach that divides these areas of law by time. The other is that once the conflict was primarily between states and non-state actors, the question of Jus ad Bellum is by many considered inappropriate, only governing the use of force between states. So we wouldn't apply Jus Post Bellum either, right? Because according to the strictly temporal approach, well, 20 years we're not post bellum. Now, in practice, this temporal approach really can get confusing. I think particularly to maybe someone who hasn't done a cursory reading in this, and I suspect even more to many living in a conflict area, right? That the question of morality and the legality regarding whether any side should resort to using force at all, it didn't end once both sides started using force. The legal justification for the use of force in Afghan territory changed from self-defense to consent for NATO forces once there was a government in Kabul which gave consent. But the question itself doesn't disappear. The beginning and ending of the conflict becomes more and more complicated as the actors involved multiply. Is there a separate beginning between Al-Qaeda and the US, NATO and the Taliban? How about the US and Pakistan? Was there an armed conflict between the US and Pakistan? If part of Pakistan's government grants permission for the use of force on its territory and another doesn't, what of other armed groups? In practice, a neat division with a moment where the armed conflict begins and ends doesn't mesh with the reality on the ground and confuses the application of the law. Take the most fundamental question: has the armed conflict ended? If so, when? Did it end when a new government was established in Kabul? Maybe after that it's a police action. Did it end de facto when a ceasefire was established under the Trump administration? Or when the US military withdrew? Officially, the US is still arguing at the US Supreme Court that it remains authorized to use force under the AUMF. So the use of armed force will likely continue. An armed conflict will likely continue also between the Taliban and ISIS-K. So with a naive temporal approach to jus ad bellum, jus in bello, and jus post bellum, jus ad bellum is functionally just a passing moment decades ago, and jus post bellum seems like it may never come. And were it to come, many temporal approaches to jus post bellum would essentially leave it, as a subset of international criminal law, another way of saying post-conflict criminal justice. And with due respect to Prosecutor Khan's renewed investigation at the ICC, that may leave the naive temporal criminal law focused on jus post bellum with little to actually accomplish in Afghanistan. Actual post-conflict justice in Afghanistan in the short term is likely going to be done by the Taliban, and it's unlikely to be pretty. That leaves jus in bello, right? Jus in bello, the law of armed conflict, IHL, it's wonderful. I have to say this at a Red Cross event, but it is true. It is a lasting achievement to minimize the avoidable harms of armed conflict, but it cannot do all the work of organizing the regulation, the management of armed conflict to peace. It has enough work to do on its own. A functional approach to jus post bellum looks different than the temporal approach. It would include the regulation, guidance for things like negotiations with the Taliban at whatever point during the armed conflict. It would include negotiations with Pakistan. It would include conduct during the armed conflict that was not about targeting. So the vaunted effort to win hearts and minds, it's central to counterinsurgency. We all know it's important. But from a strict legal point of view, it is not well regulated by the temporal view of jus ad bellum, jus in bello, and jus post bellum, outside the temporary situation of occupation. So for 20 years, well past occupation, the temporal approach to jus ad bellum, jus in bello, and jus post bellum has very little to say about the actual rebuilding of Afghanistan. Building infrastructure, building social services, ending corruption. These are regulated to some degree by international law, but primarily by the human rights obligations of the territorial state of Afghanistan, leaving the non-occupying but heavily involved foreign states on both sides of the conflict, neither forbidden nor obliged to build a road or fund the police or buy crops or build consensus about what the post-bellum regime would look like. So what if we put every one of those decisions under the interpretive rule of whether, given all information available, it furthered the goal of building a just and sustainable peace after the conflict? What if that was our main guidance? Even the operational heart of Jus Bellum, right? In the heat of conflict, targeting could be touched by this approach, could be adjusted by a functional approach to Jus Post Bellum. Targeting a Taliban fighter may be perfectly allowable in Jus Bellum. It might be proportionate, it might be a legitimate target, but it might not be worth it, as is reflected in our guidance to our military, right? The opportunity cost of the kill, given the alternatives, given budgetary limits, given the possibility of purchasing the crops of an Afghan farmer or employing an Afghan or funding an investigation into existing corruption, not making an enemy of the family of the dead, might do far more to further the possibility of a just and sustainable peace. A functional approach to Jus Post Bellum frames these questions not as a sideshow, but as the central theater of operations. I'll return to this in my fourth question. How can the goals of establishing a just and sustainable peace help answer legal questions in the transition to peace? But before that, we need to turn to my third question, right? What value is there in paying attention to the ancient traditions that used to inform our approach to war and peace? All right. A portion of my book is rebutting the supposition that Jus Bellum and Jus Bello are old and Jus Post Bellum is new. While the terms Jus Bellum and Jus Bello predate Jus Post Bellum in common scholarly usage, not as much as many people assume, the concepts behind them do not. And that becomes clear when you read the jurists that preceded all of these terms. Right? It's a fairly academic debate, but it gave me an excuse to read through many great jurists and philosophers and reflect on their thoughts on war. I think that the ethical and legal traditions that are at least somewhat remembered with respect to Jus Bellum and Jus Bello have been somewhat forgotten when it comes to the need to focus on the transition to a just and sustainable peace throughout armed conflict. That's part of the argument of my book, and I'll turn to it in answering the question of the value of these traditions. And I'll start with Augustine, all right? With all due respect to Romans and Greek philosophers, Augustine is, as we might say, my home state, Wyoming, the granddaddy of them all when it comes to the real genealogy of our thinking about the ethics of war. He is the great source for Aquinas, who's really in some ways the foundation for all who come after him in this particular field. And right at the start, in Ad Bonifacium, Augustine demands an aim of establishing an advantageous peace. He states, "Therefore, even in waging war, cherish the spirit of the peacemaker, that by conquering those whom you attack, you may lead them back to the advantages of peace." He is focusing on the idea that those who you conquer have to be led back to accept this peace, to see it as just. His great fear in war is that it will corrupt even those who begin with a just cause. In City of God, Augustine notes, "Let everyone then who thinks with pain on all these great evils, so horrible, so ruthless, acknowledge that this is misery. And if anyone either endures or thinks of them without mental pain, this is a more miserable plight still, for he thinks himself happy because he has lost human feeling. So tell me whether this, sadly, is not an apt description of many of us in the US and elsewhere who have let the war in Afghanistan, so-called war on terror, spin on and on without much mental pain. Why is this so terrible to Augustine? What happens when we've lost this human feeling? He asks, what is the evil in war? The real evils in war are love of violence, revengeful cruelty, fierce and implacable enmity, wild resistance, and the lust of power. He sees that a nation that glorifies violence, cruelty, that accepts torture will be corrupted and fall subject to the mere lust of power. And he knows that this cannot bring a just and sustainable peace. He recounts the Punic Wars, noting that any war that goes on too long cannot bring a just or desirable peace. And what I fear is not just that the war in Afghanistan has corrupted our character here at home, but that the continued ability to disregard Afghanistan or think of the suffering of Afghans without mental pain will compound the error. It will make us worse and lead us, as Augustine might have said, back into temptation, right? To think the problem was not the long and bloody war itself, nor a strategic goal, but some relatively technical fix on its prosecution or our exit. So the problem was not trivial. I say it was at the heart of our effort, right? What just war theorists might have called the res, the res, literally the thing the war is being fought over. The announced goal of the US strategy was originally to win the war on terror and to defeat the axis of evil. This res was, of course, out of scope for what reasonably could be accomplished. But the Obama administration changed the goal, right, to something more modest, but still not fundamentally focused on the Afghan people, right, on what's just and sustainable for them. The goal was to disrupt, dismantle, and defeat al-Qaeda and its safe havens in Pakistan, and to prevent the return to Pakistan or Afghanistan. That was the goal. That is what we heard continuously since 2009. And perhaps had that been the clear focus from the beginning, the US would not have been sidetracked in Iraq, and it could have been accomplished. And perhaps that was a just cause, one of the requirements of just war theory. But I can't hear that declared goal in my ear without hearing the words of Francisco Suarez from the great school of Salamanca that many credit with the origins of our traditions of international law, saying, if one prince begins a war upon another, even with just cause, while exposing his own realm to disproportionate loss and peril, then he will be sinning not only against charity, but also against the justice due his own state. The ultimate result of exposing our own nation to disproportionate loss with trillions of dollars spent? Well, Suarez says that such prince will inevitably trend towards becoming a tyrant. Or what of Gentili and his famous 3 books on the law of war? He begins his third volume with a string of quotations saying, war should be entered upon in such a way, says Cicero, that its aim should seem to be nothing else than peace. Augustine also in the Canons declare that peace should be one's desire, war a necessity, for peace is not sought in order to arouse war, but war is waged in order to win peace. Therefore, victory is the end of the general's art, says Aristotle, when the victory is characterized by honor and by justice, which is peace. The aims of the US and its allies have never been explicitly to build a victory characterized by justice for the Afghan people. but simply to rid the world of terror, or alternatively to deny al-Qaeda safe haven. Even though it was their territory, the primary goal was not to do what was best for the Afghan people, except as means to an end. So, speaking of means to an end, let's skip ahead a bit to Immanuel Kant. Okay, in particular, Kant's first definitive article in his famed essay, Preliminary Articles for the Perpetual Peace Among States. Perpetual Peace Among States. Kant declares the civil constitution of every state ought to be republican. Given his definition of republican, Kant was referring to certain basic elements core to what is thought of as democratic governance today. So liberty, equal treatment under law, representative government, separation of powers. Now, when Kant is talking about peace between states, why is that important? Kant is connecting our international collective security needs to our domestic form of government. He's, in a sense, positing a form of the democratic peace hypothesis way before it became popular. And I think he was right to do so. I would maintain that establishing a democratic government that endured would have posed far less of a threat to international peace and security than the situation we have today, where the likely civil constitution of Afghanistan is not Republican, and it's not likely to be so for some time. Let's take 2 moments in time where that goal might have been important, in part as a warm-up to our 4th question. All right, first, early on in the armed conflict, many reports indicate that the Taliban was shattered, Pakistan was intimidated, willing to make a deal. What if the goal then had not been total victory over the Taliban, unconditional surrender, if we didn't enter with an arrogance following the early military victory before turning with an even more extreme arrogance towards Iraq? Would the Taliban have been able to join in with an Islamic version of a state with liberty, equal treatment under law, representative government, and separation of powers, as exists in other Islamic states? In the first flush of victory, with the world on the US's side, would Pakistan have acquiesced? We'll never know. Perhaps not. But it's likely, if there was a compromise to be made, if any compromise was made then, it would have been better than the situation we would have today, where the Taliban feels very little need to compromise. A functional approach to Jus Post Bellum, informed by its moral tradition, with that goal, that function of guiding us towards a just and sustainable peace, not bounded strictly by time, would have kept that arrogance in check, would have compelled greater attempts to compromise and to achieve a sustainable peace early on, even if imperfect. And the second moment, well, there's right now, right? The goal of liberty, of equal treatment under law, representative government, separation of powers, remains important right now, as difficult as it seems. Not out of charity towards the Afghan people alone, not just out of understandable guilt, but out of the need to still try and build a just and sustainable peace in Afghanistan. And that leads me to 4th question, right? 4th question here. How can the goals of establishing a just and sustainable peace inform legal decisions in this transition to peace? We've already given one example of how early possibilities of peace shouldn't have been squandered. Let's look at some other examples. I maintain Jus Post Bellum should not be merely seen as criminal accountability for the crimes committed during armed conflict. But let's start there, right? It's entirely predictable that there will be credible claims against certain individuals affiliated with the Taliban with respect to atrocity crimes. So what should be done about this? It's a legal question. It's a legal choice. Does the goal of establishing a just and sustainable peace help answer this question? Does it help fortify us. On another question, the question of recognition, who will take over the seat at the UN or other international organizations? Who will take over Afghan missions and consulates around the world? And further, who's going to establish and maintain diplomatic ties in turn, reopen embassies or consulates in Kabul? They've been closed. Does the goal of establishing a just and sustainable peace help us, guide us in this question? Or if the Taliban asks for help in its fight against ISIS-K, what some would see as the inheritor of the Al-Qaeda mantle, should they receive it? Should the US and the Taliban Afghan government become now co-belligerents in their fight against terror? These aren't easy questions. Reasonable people may disagree on their answer. I'll try to address them in turn. Many people will see the impunity for Taliban officials as just more evidence of the fruitless of both international criminal law and Jus Post Bellum, however conceived. Time to turn away. I respectfully disagree. International criminal law as one component of Jus Post Bellum, it can be patient, not bound by time. Impunity for state officials, be they Taliban or the former president of Sudan, is grating, but not necessarily permanent. Even confinement within Afghanistan as a sort of glorified house arrest for fear of traveling abroad can have its purposes. Limited justice, delayed justice. It may not be full justice, but neither is it nothing. The best focus on foreign actors, for foreign actors at this point, may be just now to focus on domestic investigations and prosecutions, given that the ICC, Office of the Prosecutor, has declared their focus on the Taliban and ISIS-K. There are still victims who were tortured to death in Bagram whose families have not seen justice. Guantanamo remains open. We should start there in a long process to build a peace that may be seen as just, sustainable, and trusted by all sides, if that is our intent. And what of recognition in diplomatic relations? Again, I think the goal of a just and sustainable peace is reasonable here. I do think it's reasonable for many states around the world to treat the Taliban government as a whole as in effect persona non grata, for now using that leverage to establish what measure of justice is achievable in Afghanistan. A Republican form of government, such as Kant would have liked, is out of reach for the moment. But that does not mean there's not a compelling reason for Jus Post Bellum to operate on the question of recognition in diplomatic relations, even under these difficult circumstances, to reach the justice we can reach. And what of the war on terror? What if there is, as a phrasing goes, a terrorist group of global reach that can most easily be targeted with the cooperation of the Taliban? Or conversely, should we continue to strike ISIS-K or Al-Qaeda without the permission of the territorial state? The grand tradition in international law and moral ethics behind it that we now call Jus Post Bellum would guide us towards an answer in the negative. Better to abandon the res that has brought so much suffering than to continue down the road we've been on for the last 20 years, for our own sake, as well as those in the theater of operations. Fifth question, what's next? What should we do next? What's next in Jus Post Bellum scholarship? What's next in the application of the principles of Jus Post Bellum in the real world? What's next for Afghanistan? I wish I knew. Perhaps you'll tell me in the Q&A. I'm hesitant to talk so much about Afghanistan because I realize there are probably some in the audience who have greater expertise. That's a real focus. I'm just applying my research to this scenario to see if that eliminates anything. I, of course, have some thoughts about future scholarship, some of which I've hinted at tonight, but I'm vastly uncertain about where things will go in the real world. The only note I want to sound in response to my what's next question is not to despair. Say that uncertainty cuts both ways. And frankly, we owe it to those living under Taliban rule not to despair, but to seek creative and patient ways to work towards a peace that will someday be seen as just. So I've tried to answer 5 questions here tonight. Why Jus Post Bellum? What is Jus Post Bellum? What good is the tradition of Jus Post Bellum? How can Jus Post Bellum be applied to modern issues, and what's next? And if I've failed to answer these questions to your satisfaction, I'm happy to discuss it with you. But I hope of all the goals we seek in international relations and international law, we can increasingly focus on achieving a just and sustainable peace throughout the long transition from armed conflict to that desired state. And to end, I just want to float an idea that I can hope can either cut through the inevitable partisan debate of who of the last 4 presidents lost Afghanistan, or maybe just annoy everyone, right? Was it Bush early on? Was it Biden at the end? Here's my idea. Blame Clinton and Reagan. It's no coincidence, I think, that the great success stories of Jus Post Bellum, the remodeling of Germany and Japan from wicked regimes to modern democracies, happened under the guidance of a US that was not afraid to think big, to extend its social safety net, to take creative and experimental approaches to governmental innovation, that was not afraid to see a confident democratic government as the solution to even overwhelming problems. One can't help feel that FDR would have done a better job in Afghanistan than the US has over the last 20 years in the wake of skepticism towards American federal democracy that's haunted us since Reagan. Perhaps before asking how we lost Afghanistan, we should ask why we are losing Tunisia or scores of other struggling young democracies that could use the help of a confident democracy that believes in itself. Perhaps we could breathe life into Kant's vision of perpetual peace if we did a better job of defending and believing in our own democratic institutions. So with that, again, thank you all for listening. I really appreciate it, and thank the Red Cross for hosting me.
Thank you very much, Dr. Iverson. I hope everyone can hear me well. My internet just said that my connection's unstable. So if you can't, please let me know and I'll repeat the question. But we do have one question, and then I'm happy to just go into conversation with you and if there are no other ones. But it's kind of case specific, and the question is, what kind of lesson can we learn from post-apartheid South Africa with working for a sustainable peace? I guess, is this anything you looked at? The question goes on to say, is it taking too long, or is this the best we can hope for? And the person who asked the question said that they viewed it as functional and not temporal, as you've discussed. So maybe you can speak on that.
It's a great question. You know, again, 10 years ago, there was also, I think, a greater interest in this whole subject of transitional justice. I've written about, and much more accessible than my book, I will say. There's open access articles I've written in the International Journal of Transitional Justice, contrasting transitional justice and Jus Post Bellum. With transitional justice, which is really the operative term for South Africa, it's this idea coming from Southern Africa, from Eastern Europe, from Latin America, that we're transitioning to democracy, right? Now that's always nice, but not necessarily the only core goal of Jus Post Bellum. You know, you can have armed conflicts that, you know, don't involve the transition to democracy, but can resolve in a solution, you know, Falkland Islands, Malvinas. I think there are a lot of lessons from transitional justice, and you can think of transitional justice and the transition to democracy as it could have and should have been applied in Afghanistan, and still should. I mean, I still think there should be, as I hopefully tried to present, a real maximum effort to hold those accountable we can, and to try to still have that long-term goal of getting towards democracy. But I think we also have to be realistic to say, in the short term, that's not going to be what we're facing for justice. We're going to be focused on basic human rights like the right to life and maybe the right to education.
All right, and then I kind of wanted to go back to something you said earlier, because it's been something that I've been thinking about, and it has to do with recognition and the diplomatic side of all of this, which I think is a big portion of all, the transformation part of it. And I'm wondering your take, like, is how you approach the recognition and the diplomatic side or the policy side kind of a case-by-case basis. So for example, we kind of have this approach to Afghanistan with some major state powers being like, you prove to us that you meet the standards of how a state behaves, and then we'll have this recognition. And then there's this other side that says, if you recognize them as a state, like if that's how we're doing state recognition, you kind of bring them into all these past obligations that the state of Afghanistan possibly had under treaties. So that's one point when it comes to Afghanistan. But then you also have this other side of post-Bellum. You mentioned Colombia, where the kind of recognition of the FARC, for example, as actual political actors now, and not necessarily like criminals, and they're able to have a political party and join the political system. And that's had a huge impact on the Colombian people, a lot of Colombians, support for the peace process. So would you say, when it comes to recognition, diplomatic, one, like, what is your response to what I said about Afghanistan? And then two, that we see how there are two negatives. There could be negatives at times of doing the recognition thing, because you might lose the support of the populace for that transition from war to peace, as we're seeing in Colombia, and hopefully it will continue to improve and be sustainable as it has been to a certain extent.
Yeah, interesting sort of interlocking queries there. Of course, legally, the sort of question of recognizing a government versus the sort of decision to talk with a non-state organized armed group are fairly different, right? But maybe there's sort of a common logic there. And for me, I think the common logic is, what do you get for it? Right? What's your goal? And that's, to some degree, the point I'm continuing to try to keep driving home. We've tried non-recognition of the Taliban before, right? But if you're just not recognizing, for the sake of not recognizing, to sort of spite you and not trying to get something for it, and just hoping they'll go away, well, that's on one side of the spectrum. And then, on the other side, you can sort of say, well, we're going to recognize you right now, because we want to be friendly with you. And I think we'll probably see that fairly quickly from perhaps China and some other states. They want good relations. They want to deal with the Uyghur situation. I think that states should use what leverage they have, and it's different leverage now, obviously. But there still is obviously leverage to try to push for the guarantee of certain basic human rights. And that's the best just peace we can get. So that's an active negotiation. With FARC, obviously, peace can be unpopular and rejected, and you have to, make it just enough that it can be commonly accepted. So maybe giving too much away to the FARC makes it neither just nor sustainable. But at the same time, this is, talking from the cheap seats for me, right? It's a very difficult problem to solve. And in some ways, an imperfect peace is still better than an ongoing armed conflict.
Yeah, and I know I completely agree. I think the concept in general is one for academic discourse and and policy implementation. But I mean, you're always going to have different perspectives, and it can be a lot more complicated than people think it is. And that's actually why I enjoyed reading your book so much, is that it's one perspective that focuses on a lot of different areas and a different voice in one cohesive thing. So I'm not reading a bunch of different articles. It's all right there. So I do appreciate you taking the time to put that out. Another question that we had was, what do you think of and I'll just read the question as it is, but what do you think of the budding concept of jus ante bellum or jus ad bellum? I think they're referring to its relationship to just post bellum in general.
Right. So, there are possibly too many names and terms and confusion, and the same term being used in different ways. I think it can be helpful. I think my structure is the most helpful. But one of the things that a lot of good scholars have brought in is to bring in different components to sort of say, well, maybe we should talk about lex pacificatoria, right? The law of peacebuilding, right? The law of actually getting to peace agreements, recognizing that very frequently there's not one peace agreement, but a series of agreements over time. So that's Christine Bell. She's a genius. She's done fantastic work there. Or jus terminatio, right? The law of terminating the law. And then there's been really good work talking about, the particular aspects of post-conflict justice, and sometimes that's broadened beyond international criminal law to other aspects of distributional justice. That's been discussed for a long time. So there's a lot of good work, for decades now, using different terminology. I think the key thing is not to sort of get lost in the terminology, but to bring out these concepts, which really haven't been there for the last few years or the last 20 years, but in some cases for centuries, right? That you do want to say, Afghanistan, in some ways it's sui generis. Our current moment is hard to compare with others. But in some ways, you don't want to be so arrogant as to say we have nothing to learn from the past, even if they wrote it in a different language or had different concepts. I think there's a lot of good material there. So I'm sorry if I'm not answering the question too directly. I think the general idea of focusing on the particular aspects of post-conflict justice or antebellum can be helpful.
Right. And then I guess going back to what you've discussed already about, we can learn from the past and specifically centuries and centuries ago, these philosophical thinkers. Could you recommend to our audience like any text that, you've already touched on some, but any that you would recommend that people check out? And I also think it's important to raise the point that a lot of, the beginnings of our modern IHL system, so different area of law, the jus in bello, developed out of customary practice and people studying, such as Lieber, studying the historical practices of modern state militaries to create the Lieber Code, which impacted the 1864 First Geneva Convention, et cetera. So could you recommend anything? Because I think that is key to creating a more creating a conversation and making the conversation about this topic more beneficial.
Well, as I mentioned, with the Jus Post Bellum project here at Leiden, we put out a number of volumes, and the wonderful thing about them is I wish, to be honest, my book was open access too. Maybe at some point I'll get a grant and pay off the publisher, but we paid off OUP. So you all can read those books and you don't even have to read all of them. You can go down to the specific historical ones. So if you're really interested in Jus Post Bellum as it applies to, the transition in Japan after World War II, we have a chapter on that. So there's a lot of open access stuff that has come through the project. More generally, if you're interested in really good historical work, I would say Lefevre is a great author for sort of the deep roots of a lot of this, before it was separated out into jus ad bellum, jus in bello, when it was more of a common just war theory. And I did like more recent, the Lincoln's Code book, about the Lieber Code. I thought, for an American audience in particular, I thought that was quite good.
Yeah. Yeah, it's a very interesting text as well, especially from an American historical perspective. We do have another question, and it has to do, and it says, how does military occupation law fit or not fit into your conception of Jus Post Bellum in the 21st century?
So, occupation law has always been, traditionally thought of as part of Jus in Bello, right? And so, it can feel a little funny, because, again, when people, sort of think of Jus in Bello, it's a lot, right? There's all sorts of things in there, from targeting to, what you have to do with a floundering ship, to prisoners, to, the obligations of an occupier. So I think, most Jus Post Bellum scholars have been content to leave occupation law proper to, the realm of IHL. There's been some nice, what is law in terms of transitioning from occupation. So Yale Ronan has written some nice articles and chapters about that. Obviously comes up in the context of Israel, in terms of the Gaza Strip in particular, about ongoing obligations. My view is that some of the key regulations coming from the Hague regulations, sort of saying, hands off, don't change anything, don't change the local laws, you don't touch, really don't make sense in the terms of long occupations or long transitions from occupations. I think there's a reason to have more of a bias towards democratic transition. If the previous regime wasn't democratic, I don't think you can justify not, especially for something where you're there for a considerable amount of time, build towards a democratic, human rights respecting entity. So not everyone agrees with me, but that's how I would integrate it. I hope that makes sense.
Well, we're just running out of time, and so I just want to thank you again for sharing your expertise with us, and sharing what your book is about and giving us your perspective on this very important topic. So thank you to everyone who's in attendance. And for those of you who had to leave early or joined late, please, you will receive a recording to where you can access the recording via Zoom, and we can move forward, continuing this discussion together and further on in the world of academia and in the Red Cross community. So thank you again, Dr. Iverson. I really, really appreciate it. And congratulations on the book. Once again, it's a great read.
Thanks so much for hosting me. And thanks for all your great questions.
Thank you.